This is Making the Case. I'm Yodit Tewolde. We begin tonight with two cases where the presiding judges are drawing criticism and backlash. Starting with the case out of Illinois, where Judge Robert Adrian has come under fire for overturning the sexual assault conviction of 18-year-old Drew Clinton. During a bench trial, Judge Adrian found 18-year-old Drew Clinton guilty of sexually assaulting an unconscious 16-year-old girl during a graduation party. But during sentencing, the judge explained while he knew by law Clinton was supposed to serve prison time, in this case, he says he felt it was unfair because he had just turned 18 2 weeks before the party and had no criminal record. Clinton served 148 days of what was supposed to be a mandatory 4-year sentence. Joining me now to talk about this case and other trending legal stories is veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Brian Watkins. Glad to have you both on. Paul, let me start with you. This case is reminiscent of 19-year-old Brock Turner, the white former Stanford University swimmer who was convicted of 3 felonies for sexually assaulting an unconscious woman who only served 3 months of a 6-month sentence. Here you have another white boy, Drew Clinton, an 18-year-old, who this judge convicted of sexually assaulting the 16-year-old while she was unconscious, meaning he found that the state met their burden of proof. But in this punishment hearing, he now said the state failed to prove their case. So he reversed his own decision and threw out the conviction and thought that the 5 months Clinton spent in jail was, quote, plenty of punishment. Now, this would never happen for a black defendant at any age, and nor should it, but I had to just state the obvious. So your initial thoughts, please.
Okay, my initial thoughts were very similar to yours. That's exactly the other case that I was thinking of as I was reading about this case and what the judge did. And certainly what I expect of what's going to happen here is that prosecution is both going to challenge that ruling, hopefully, and take it up on appeal, but also report the judge for his inappropriate judgment and comment. I think one of the things here that we have that's going to help overturn or challenge at least this decision are the statements that the judge made where he indicated that he didn't want to rule or wasn't going to rule to avoid being bound by the statute. That is not something that you can do. Judges are giving wide discretion, but the real issue is here that I think, as you raised, is the sentencing disparity based on race. And we know that based on race, that African Americans have 20% higher charges and sentencing based on no other standards than race alone. So in the exact same kind of charges, a 20% disparity, and it's because of cases like this. And so I know that judge has already been assigned to the civil side of things and has been reprimanded internally, but now the challenge will be whether or not that ruling gets overturned by his peers as a superior, or he gets disciplined by the Judicial Council in that state. That's what I'm looking for. And we haven't even unpacked the comments that he made about the woman, the young woman that was assaulted, which were also really inappropriate and disrespectful both to women and domestic violence and sexual assault victims in general. That's a whole nother conversation, but I'm raising the flag for it.
Brian, again, Judge Adrian said that he knew that by law the defendant was supposed to serve time in prison, but in this case the sentence was unfair, partly because Clinton turned 18 just 2 weeks before the party, and until his arrest had no criminal history. That this wasn't just, and that he wasn't sending this teenager to the Department of Corrections. He said all of this in front of the victim who was sitting in court. Your thoughts, please.
Well, it's a double-edged sword. The same argument, and people want to protest and raise and say, we don't like mandatory sentencing guidelines in federal court. We want the judge to have discretion to be able to do things. A lot of the people that we see being released, Kim Kardashian got a woman released for a marijuana conspiracy where she was doing an excessive amount of time. Why? Because the judge didn't want her to give her that time, but he had to because of the mandatory minimum sentencing guidelines. And so when we fight back against mandatory minimum sentencing guidelines, we're saying the judge should look at the facts, look at the evidence, and look at the mitigants, things such as he just turned 18, he has no prior criminal history. Those are mitigants that judges must consider. And we give the judge that discretion, and then he has to make the call. So it's tough to Monday morning quarterback that. So the question is do you want mandatory minimum sentencing guidelines? Do you want it hard stone in the book? Or do you want judges to be able to use their discretion? And when you have judges using their discretion, sometimes you're not going to like his decision, and sometimes you are. But that's the predicament that we're in. The justice system is not perfect. It's just the best that we have.
Paul, according to the local outlet, the Quincy Herald-Whig, the judge was so angry by the backlash that he received, he kicked a prosecutor out of his courtroom who had liked a comment on Facebook that criticized his ruling, saying, quote, "I can't be fair with you, get out." Now, you mentioned the judge has since been removed from handling criminal cases and is presiding over other legal matters, but should he be on the bench at all?
I don't think so, based on the behavior that I've seen from this case. But one of the tools that prosecutors, as you know, has is to challenge the judge generally and say that he's not fit to hear any of their cases moving forward, in which case their cases get reassigned to someone else. Now, in this situation, they've already moved him, but the behavior from this judge on all three of those counts, the discretion that he exercised, which, by the way, we generally want discretion, but we want discretion that's equitable as defined by a race analysis as well. And that's what we never get to see. That's part of the problem with having discretion or the lack of discretion. The secondary thing that I have concerns about with this judge are the comments that he made about moving and changing what he knew that he had to do to avoid having to follow the law. And that's before we start addressing his inappropriate comments about the victim herself. And then strike four is the comments and the inappropriate behavior and response to the prosecutor who had been in his case that obviously he was tracking to find out that someone had liked something that was against one of his rulings or himself. And he took that personally and made the statement that he did. That's not what we expect from our judicial officers. And that's why this judge should be in the trouble that he's in. And I'm waiting to see what the repercussions will be in this case, though, if it's made more equitable or if it will be resentenced by someone else at some later point in time.
Brian, look, I don't think that public opinion or movements like Me Too should ever influence what goes on inside the courtroom. But this judge did find this defendant guilty in a bench trial. And the victim in this case had to muster up the courage to testify and relive a traumatic time in her life. Then to have this happen, no less right in front of her, where this judge expressed his sympathies for the defendant, but had no regard for her feelings and what she had to endure. What message does this send to sexual assault survivors and society as a whole?
I don't know that we could say that he's sending a message to sexual assault survivors or anyone like that. I mean, the judge is in the position to make the decision. And one side is always going to dislike the judge's decision. That's just the way it's always going to be. And yes, this victim came forward and she testified, and the judge evaluated the evidence and determined, weighed the aggravants and the mitigants, and came with a decision. But I do not support at all this justice by internet or justice by public opinion. I don't think a judge, should have his rulings questioned like that once he takes the bench, unless it's a foul of the law. That can be appealed. But comments that people don't like or take as disparaging that weren't meant to be or were meant to be or whatever the case may be is very subjective. And I don't think that judges should be, Monday morning quarterback. And every time you don't like the way a ruling is, and most of these people who are commenting who don't like the ruling didn't listen to the trial, didn't hear the evidence, and are just basing this on what they've read or saw on the internet, portions of which they read and saw on the internet and derived their opinions from. So it's a tough decision. We have judges up there making the call, and he was a good judge. He's never been reprimanded before. He's made many other calls, and people don't like this call. I don't know that there's anything that we can do about that, but for a legal error upon which can be appealed.
Well, Brian, I mean, the judge did make some comments that I don't think were subjective. I don't think that they were left up to interpretation. I mean, he did mention that the victim was wearing underwear instead of swimming, a swimsuit to swim, blamed parents for throwing this party and giving alcohol to kids. Everyone got some blame other than the person that he initially found guilty. Paul, your thoughts on that?
That's exactly what I was going to raise. And his job was to hear the trial and the evidence and the case against the defendant. It was not his job to comment and support or challenge the judgment of the victim, to challenge the parents of the people that may have been involved. And those might have been influences, but the real issue is that judge was there to address the defendant specifically. And I thought the comments were inappropriate about what the victim in this case may have been wearing and his judgment about what she should have been wearing. And it opens the door to older way of thinkings that we have evolved from and we have moved on from, where we are judgmental about victims for seducing or enticing someone to assault them or to rape them in this case. I think the comments were very dangerous that the judge made. I am judgmental about the comments that he made by not focusing just on the behavior of the defendant. Of course, he's a judge, so he's allowed to exercise his subjective interpretation of the evidence that gets presented to him. But in this case, it crossed that line and he went too far in trying to diminish or challenge or put down the victim for behavior that I think is inappropriate. And that's only part of the reason why I think he's under censor right now and why he's going to face some challenges about his behavior in this case from not just prosecutors, but from other judges as well.
All right, Paul, Brian, please stand by. We've got more cases to cover with my panel of experts on the other side of this commercial break. You're watching Making the Case. Back with me are my panel of legal experts, veteran prosecutor Paul Henderson and criminal defense attorney Brian Watkins. All right, guys, let's turn now to another crazy, bizarre ruling by a judge out of Kentucky. Brandon Scott Price, a former prison guard convicted of sexually assaulting an incarcerated woman, was given the option of serving jail time or joining the military. The defendant, who's an Army veteran, obviously chose the latter, so Judge Thomas Wingate ordered him to re-enlist within 30 days. Brian, when does a defendant, and here we're talking about someone who used his position of power to prey on someone who was clearly vulnerable, and sexually assault them, be given any options, much less one that avoids any consequences?
Oh, that ruling there, I don't understand at all, because the Army won't accept you if you have a sexual assault conviction or felony on your record. So I don't know how his order is even going to stand up. The Army won't take you. I have people who, out here in San Diego, we have Navy SEALs. They get kicked out for having a DUI. So the individual won't be able to join the Army. So I don't know if his ruling is going to have any power whatsoever. It's a silly ruling. And like I said, the Army's not going to even accept him with a conviction on his record.
Interesting points. He also told the defendant that if he didn't re-enlist within 30 days, that he would have to report to that local jail facility. All right, so Paul, the judge told Price that he was getting a huge break, that that he made a terrible mistake, one that cost the county money. Never mind that the woman he was transporting to a medical facility alone, which was against department policy. Then on the way back from that facility, he pulled off onto a side road and asked the shackled woman to perform oral sex in exchange for early release. His actions still cost the county money. That's the point. What does the judge's statement say about how we treat incarcerated people?
It says quite a lot. And to the point that we were just discussing, I don't think it matters if he could join the military or not. What matters is that the judge gave him that option of doing anything other than going to jail, which would be the standard sentence for behavior like that. That would be the standard sentence for a sentence based on behavior like that. And so to me, that was an abuse. That was not what the judge should be doing. And that judge is likely to face a challenge for making the decision right there. And the other thing that I want to flag in this here is, beyond just an individual defendant making a bad decision like this and ending up in the criminal justice system, this is a deputy that is on the arm of law enforcement. This is a representative, and that abuse of discretion elevates the concern that I have, not just about the transgression and the crime that he committed, but about the abuse of discretion that he used his law enforcement position on for against another person. That's an aggravating factor, not a mitigating factor that should have been giving him extra allowances that no one else would have had. There's so many red flags raised from that decision or the offer from the judge. Whether or not he takes it or not is a real problem, and speaks to how we see not just folks that are in custody that have constitutional limitations because of their situation, but also on how judges allow or cross the line in exercising their discretion. This is a real problem.
All right, guys, now to LA, where two LAPD officers lost an appeal and their jobs after failing to respond to a robbery in 2017 because they were too busy playing Pokemon Go. I'm actually really exhausted at this point when we talk about officers. So I'm going to let you guys just sound off. Brian, you first.
Yeah, again, I don't know what to say. Why they weren't immediately terminated is beyond, my recollection. I can't even fathom why they wouldn't immediately terminate it or something like that. God forbid someone was hurt or killed at that robbery. Then, I would want them to be put up on charges for just deliberately derelict of duty there. But, it's the cops have, we need police. I understand that. They've caught a lot of flack recently, but things like this don't help their cause at all. I mean, to sit there and play a child's game when you're a sworn officer and someone's in danger, like I said, immediate termination. How they did not get immediately terminated, I don't know.
Paul, and then they had the audacity to appeal that decision that they were terminated based on the fact that the body cam footage, their cameras were used in trying to figure out what happened that day, and they said that that was a violation of their rights. Your thoughts?
The chutzpah, that's unmitigated gall to challenge the decision that removed them from office. This was more than a dereliction of duty. It was a violation of public trust and a violation and fraud of taxpayers' money who are paying for that service, who are paying for that definition of public safety to have the officers behave this way for a known crime being committed. And one of the things that it raises to me, because we did go back and check the body-worn cameras, that's how this all got uncovered, the information that was in their cars that was recording them. So it was captured, but the nerve to have the officers challenge it. And certainly we all have our own constitutional rights and due processes for these behaviors and these actions. But we also know what common sense tells us, which is that this is a disgusting failure of people to handle and to do their jobs. And I'm concerned. I also want to know, I wonder what neighborhood this was in. I wonder whose taxes were paying for service like this. And so the fact that they were fired means that our system is working. The fact that they have the ability to challenge that also is part of our system, and that's the due process. But I think we got to the right results here. But I'm infuriated by the behavior itself, that this is what happened and this is what is happening on our streets. But I'm glad it got caught, and I'm glad it was addressed, and that the result is the way that it is from this case. These are not, but this is not the only case. I've seen cases like this.
Well, guys, let's turn now quickly to Baltimore, where Marilyn Mosby, the city's top prosecutor, has been indicted by a federal grand jury on charges that include perjury and making false statements. Really quickly, back to you, Paul, because we talked about this probably about a week ago, where Black people in positions of power are scrutinized more. That essentially we can't do what they do, right? But some are saying that Mosby has always been a target since she prosecuted those cops involved in the death of Freddie Gray a number of years ago, and that this isn't coincidental that she's up for re-election in June. What are your thoughts?
Well, and that's exactly what she is saying too. And listen, I know Mrs. Mosby. I think she's a great prosecutor and a good lawyer. I share a lot of the values that she has. These charges are coming, and charges are charges and violations are violations. I would like to unpack the discretion, though, that prosecutors have and how they charge cases and what they charge and when they charge. And I think that's the issue that she's raising, that she is being prosecuted now right before her election for things that took place a while ago that she believes she will absolutely be found innocent of. And I've drilled down deeply to find out what those actions specifically were, because I just have personal interest in wanting to know. And basically what she had done was go into filing papers and documents to access her own funds from her retirement in order to buy investment property someplace else. And the discretion is that you're not typically allowed to access those retirement funds. But she said that she had repercussions during COVID and needed to access the funds. And that's what the challenge is. The prosecution is saying that that was not true, that she did not have a valid reason to access her retirement funds. And so they filed these perjury charges against her, which, by the way, carry a charge, an exposure of 5 years for each count. And there's 2 counts, so that's a 10-year exposure for these challenges. I mean, it's a tough case. It's a tough situation, but those are the facts. And I don't think the facts have been really fleshed out publicly about what the charge actually means beyond just the perjury allegations.
Brian, what are your thoughts? I mean, people, on the internet are saying, we had a whole president who lied, cheated, and stole, and still walked away unscathed, no charges. You have the insurrection on January 6th, and people can't be indicted. Those political players, that is, that had any part that they played on that day. And you have this woman who essentially was trying to take her own money, is what the arguments are on the internet, that is, that she's doing what a lot of people do, not to excuse what she's done, but to go after her, to spend so much of the time and the resources to go after her is just something that people feel is just a target move on the part of politicians there in Baltimore. What are your thoughts?
I mean, clearly there's probably some, politicians that are behind this. The problem is that she knows that she's being scrutinized. And so whether or not she did lie on those applications, I mean, it's going to be a very straightforward case. She wrote things down on applications, and either those things are true or they're false. Apparently, the prosecution can prove that they are false. And so the fact that she would do something to purchase 2 investment properties is, baffling to me. When you're in that position, you're being scrutinized, to do something so silly as to lie on an application when all eyes are on you. I have to say that it was a bad move on her part. Now, whether or not she did it or not, I don't know. But like I said, it's a very clear-cut case. Either she wrote down a lie or it is not a lie. It can be proven to be true. So I think it's a very straightforward case, but I don't know why she would think that people would let that slide. And it was very, very irresponsible for her to do that in the position that she was in.
Very good point there. Paul Henderson, Brian Watkins, thank you guys so much for your insight and your time tonight. Appreciate you both.